by the Constitution. He can issue, or she can issue someday, executive orders. You have a Congress that makes the laws, we call those statutes. And congressmen, in our case, have two houses. One is the Senate, where there are two persons from each state who go to Washington representing their state, and the House of Representatives, which is made up of representatives from the states in the lower house, based on the population. I'm going to talk about that in a minute, how they treated us at the making of the Constitution. And then you have a third branch of government called the judiciary, or the court system. And they make the law. The sources of law in the United States are the president, the office of the president, the Congress, they make statutes or written law, and the court, which interprets the law. That's our system. And it's for both the federal government, the national government, and for each of the states, and we sometimes break it down into the cities, the municipalities. That's the source of the law. Now, it doesn't mean the law has to be great. It can be stupid. It can, if enough people vote for a dumb law, then it becomes the law. It doesn't make any sense. It can be great, and nobody, or very few people, obey it. And so we have to have another system called the enforcement system. We also have to have something called interpretation. Let's play a game. You're going to be lawyers. I made you lawyers. Magic lawyers. There's a statute that has been passed by the legislature, and it provides a tax on motor vehicles, TAX, on motor vehicles. And it powers the head of the tax department to impose this tax. So the first thing the tax regulator puts a tax on is our cars. Then he decides he wants more money, so he puts a tax on boats. It's a city with a river, with 3 rivers. The boat owners object. They say a boat is not a motor vehicle. And the tax guy says, yeah, motorboats have motors, and they carry you from one place to the other. Is he right?
Yes. Yes.
That's what a motor vehicle is. Okay. Then let's put those there. I haven't agreed with that. That's in the cooking. Yeah, it's warming. Get a little power. Next he says, I will move to airplanes and put a tax on airplanes. Is that a motor vehicle?
Yes. Yes.
Really? It has a motor and it carries you somewhere, right? Okay, so the airplane people and the boat people go to court and they say it's unfair. The legislature meant cars. They meant motorcycles that travel on the ground with wheels. They mean no airplanes and no boats. And they go to courts because the courts decide disputes. That's what a court does. How did the court rule? Yes?
They, not in favor of the people because...
Wait, people. Not in favor of the...
The voters.
Not in favor of the voters of the airplane.
Not in favor.
Yeah, not in favor.
You agree with her?
Yes.
Why?
I would like to say, but what if they have to get somewhere and but the planes have to go to the airport, but how are they supposed to get home?
Wait, now the people? Well, he put a tax on the airplane, not on the people. So,
Cars to get home.
well, the tax only says you got to pay them money. It doesn't take the car away. But
They would have favored them because they didn't say specifically a car or something that rides on
it's
the
just a
ground.
motor vehicle.
Yeah.
And this has a motor and it carries you somewhere.
Yeah.
Well, the court, this is a Massachusetts case, the court said, no, the intent of the legislature, now the court, that's what the court does, what did they think, what they have in mind? It meant a 4-wheel or 3-wheel motorcycle or 2-wheel vehicle on the ground with a motor that drives you from one place to another. That's what the court said. Say what?
They never said that specifically. It should have said that specifically.
That's what the court's job is, to say, what did they mean? Okay, so I made a point. I'm going to tell you what the point is. We have a system which allows one group of people called the Congress or the state legislature, in the case of the state, that makes the law, writes the laws in the statute books. We have another part of the government that interprets the law. That's the court system. And we have another part of government that enforces the law. It's the president or the mayor or the governor of the city, state, or country. They don't have to agree. So part of the law, I'm destroying your whole thing about how wonderful the law is. Part of the law is people sit there and disagree all the time. And so Congress makes a law, and somebody says, I don't think that's right. Or the state legislature makes a law, and somebody says, I don't think that's right. We go to court. And that's part of our system, and in sometimes it's very good. We win. We won a lawsuit in 1954, which overturned a long series of laws that said colored people have to be segregated and can't use the same places or restaurants or bathrooms or movies as white people. Water fountain, thank you. You all know about segregation. Separating. Colored people have to go to the colored part of the bathroom. And they can't go to the movie downstairs. Go upstairs. We fought that. We, the NAACP and others, fought that. It took us a long time. Finally, we were able to convince one court, after many years, in a school case, which involved 5 different states with segregation based on race. And the reason we were able to change that, I was in law school at the time, was that we at the NAACP proved that separate was never equal.
Good.
Now, why did we talk about separate but equal? Because Congress passed a law after the Civil War, which said you have to provide equal protection of the laws. Part of the 15th Amendment, 14th and 15th Amendment. Equal protection of laws. So the state said, well, we'll build 2 systems, and then we have colored system and white system. Well, the systems were not very good. The white school was bricks and mortar and glass and beautiful library and great seats. And the colored schools were little shacks. The paint was falling, if they had a ceiling, it was falling in. There were no windows, no glass in the windows. Books were 400 years old. And the court finally said, they're separate, but it's not equal. And another thing the Supreme Court did, the highest court, this is after 60 years of agreeing with separate but equal, the court said separation itself, the act of separation, makes it unequal. And the reason they could say that was the NAACP lawyers had a PhD social scientist who conducted tests with young African American children. And he gave them dolls, some brown and some white. And the African American children, and they said, pick who's better. And the African American children picked the white doll because the system taught them that white was better. And so that was part of the evidence that finally convinced the court, after 68 years of agreeing that separate but equal was good, finally convinced the court that separate by itself was unequal by definition. I don't know how the court would go if the schools were exactly the same and if the books were the same and if the paint was the same and the glass was the same, but it wasn't. And in the segregation of the movies, it was the downstairs was wonderful. Upstairs, you had to go up creaky little stairs, and sometimes the smoke from the camera would come.
Wow.
And it was different and bad. You have a question, my dear?
I don't know what to say.
Oh, say anything. Say hello. You did have a question.
No.
No, he just wanted
Okay, you're stretching. I'm sorry.
to, no, he just raised his hand. He just wanted to raise his hand.
I'm sorry?
He just wanted to raise his hand.
Okay, very good. Next time when you raise your hand, you'll ask, make up a question. So
Okay.
part of the law is resolving those kinds of fights. Now, the law is not perfect. and never will be, because the law is made by people. And people have different interests.
Yeah, yeah.
So if I'm representing farmers, because I'm a farmer and I'm in the legislature, I'm going to take care of farmers' interests. I don't care about all you city people. I don't care about all you union workers. I don't care about anything except the farmers, or vice versa. If I'm a union guy, fight for the union. I don't want the business. I don't like the business. I'm a business guy that is. I come from business to represent the business. So it's interest. Question? Oh, you straight here. Make it loud so they can hear you.
Because wasn't it hard to find a lawyer in court? Really, like a day separation?
The question is, was it hard to find a lawyer? Yes, it was hard to get good representation, because the system also, when I say system, people with power control things, and they wouldn't permit local lawyers to represent people of color because they threaten them with losing business and so forth. That's why the NAACP had a national office, and they would have lawyers from New York and from the big cities in the state represent people. I've tried cases and represented people in almost every state in the union, and there's a system we have which allows a local lawyer, somebody from, let's say, Iowa, to introduce me to the court for that case so I can represent the client in that case. All right, but the law, I want to make the point, the law is people getting together to make a law. It is not pure and equal and fair. It's what the majority of the people who have to vote in that legislature, whether it's the Senate or the House or the City Council, it's the majority making a rule. And our Constitution, started out by our founding fathers, made a rule that said when we build the Senate and the House, they'll be represented in the Senate by 2 people elected from the state for every state. But in the House of Representatives, they'll be represented by a percentage of the population. But we won't count, in deciding what the population is, Indians, and they use the word that we still don't understand called others. Them and us, brown people. All others didn't count. Indians they named, and then all others no. So that was, and it was all others 3/5 of them. So we were 3/5 of a human being, all black people. Free, slave, didn't matter. In the population they counted, but only 3/5 of them. That was the 3/5, and it was a compromise, because that's how people make the law. I have one position, you have another, we get together and talk about it, or if I do this and you get that, but then we compromise. So the compromise is called the 3/5 compromise, and it made the law. Now I'm going to destroy one of your great, how are you, Miss Lily? Nice to see you. I'm going to destroy one of your great dreams and stuff they taught you in school, the Emancipation Proclamation. Wonderful. Free the slave. Mr. Lincoln don't free the slave. All right. He didn't free, well, he did. He tried to free the slave. But the Emancipation Proclamation was a strategic wartime action. Mr. Lincoln said, I free all the slaves, all the people who were slaves in the warring Confederate region of the country. He said nothing about the folks up north or anything about the people in the territory that the Union Army had collected and captured, like Northern Virginia and so forth. So he freed the slaves in precisely the place where he didn't have any control. That was part of the Confederate Army control. It's like Mr. Obama saying, all the people in Egypt are free. He has no control over Egypt. They're bombing Egypt. So it was a strategic thing, very good for the war, because the slaves heard about it. Said, well, I ain't chopping no more cotton or carrying no more logs for cracker. And they just started disappearing. Could we free at last? And Juneteenth Day. So it was a great God Almighty.
Yeah.
But the point is, it was a great piece of strategy, but it was not freeing the slaves from slavery. It was a jive promotion. We still celebrate it.
Yeah.
No, it's fine. We feel good about celebrating, but we have to understand that the law is whatever the people make it. There's no magic. And then putting aside big things like world peace and so forth, everyday things come down to one side fighting another and trying to win. Either trying to convince a judge, my side is right, or convince a jury and then a judge. And so it's a game of strategy. We have to have, this is my commercial, we have to have more young people interested in the law so that we can have more people of color in the profession.
Yeah.
I was the only male in my law school, African-American male in my law school class. There were two women. One was in the daytime and one was in the nighttime. I went to NYU, they had a night school. Out of 378 or some number. One male and two females, one in day, one in night. Now our law schools are much better represented. We have African Americans in schools here and in New York and everywhere, and it's terrific. We've begun to have an impact on the law. Okay, I want to make one other point, or underscore one other point. There is no pure final answer. The law is whatever that you can reach up in a book and come out. Aha, the answer is green. And there's no special place we can get that one in. It is how, one, we get the compromises in the legislature to make the law. It's how the judges can be convinced one way or the other, and they may have their own prejudice. It is how it's interpreted, and that depends on what the judge brings, man or woman, brings to the decision, all of his hatred. Let me tell you a story about hatred. There are a lot of stories about hatred in the law. There was a justice on the Supreme Court, his name was Bandana. He was there from the early, or the middle 20s to, I guess, about the Depression time, a little after 1940, he probably left the court. He hated black people. Deep in his heart, he hated black people. Now, the Supreme Court's made up of 9 people, and they sit in judgment, final judgment of major cases. Charles Hamilton Houston, a name you should know, one of the great heroes of American history, African American history, was the man who developed the plan to use the law to change segregation and discrimination. We'll fight them in their own arena. Other people can sing and dance and petition. We're going to bring cases. And Charles Hamilton Houston was the dean of Howard Law School, and he devoted himself to finding the best and the brightest of students to become well-trained lawyers of constitutional law. One of his students was a man named Thurgood Marshall. Have you ever heard of Thurgood Marshall?
Yes.
Yes.
Name rings a bell. Trained by Charles Hamilton Houston. My mentor, a woman named Pauli Murray, trained by Charles Hamilton Houston. Best lawyer, brightest, fantastic person.
And now a saint.
Say what?
Pauli Murray, and now a saint.
And now a saint. She tackled something she called Jane Crow, which is discrimination against women specifically. Then she tackled the Episcopal Church because they had no women priests. She was the first woman priest in the Episcopal Church, having gone to seminary to be properly trained. And she's my mentor, was my mentor. And she knows my daughter, who we'll call her Aunt Pauli, is my grandson, Mello. How are you doing there? But I want to make the point. Now, Charles Hamilton Houston also practiced law, and he was representing a case at the Supreme Court. He's going to make the argument. He wore a frock coat, looked very special. He say, "May it please the court, my name is Charles Hamilton Houston. I'm representing the appellants in this case, and my first point is blah, 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 blah." Justice Bandana is one of 9 people on the Supreme Court when Charles Hamilton Houston got out of his chair to walk to the podium to make his argument. Justice Vandeventer turned his chair around so the back of the chair was facing the speaker's podium. Now, if you want to guess that he was kind of biased against black people, I think you'd make the right guess.
Right.
That was the one form of justice that we used to have. A justice wouldn't even hear. I don't want to hear you. I want to look at you. I don't want to. So, now, we have to then remember that it's always going to be a fight. A challenge, because there are folks who are against us. And at the local level, at the state level, at the national level, we have a continuing fight. By the way, we have a lot of good examples now of winning that fight.
Yeah.
The law is a mechanism, a device, a thing that can go either way. We've had bad laws, we've overturned them. We've had bad laws we haven't been able to overturn. But we have to keep turning out lawyers, men and women, who will go get smart as heck in law school, well, college, high school, to be able to carry on the fight, because there will always be this tension. Between those who want to keep us down and us wanting to get out. I did the Emancipation Proclamation. I did the law. I did a really quick study. The law is also lovely. I love the law. I'll tell you one personal thing and then open it for questions if there are any. When I was in law school, the cases, there were 5 cases that were put together to become the Brown cases from 5 different states, challenging separate but equal. And they were on their way up to the Supreme Court. And they had a thing at NYU called honors paper. And I wrote an honors paper analyzing those cases as a law student would do, with beautiful footnotes and all that stuff, show-off stuff. And then I came to a conclusion that the Supreme Court would overturn this long-standing precedent, we call it, called Plessy versus Ferguson, that said separate is okay so long as it's equal. My advisor, who was also the assistant dean, wrote A+, good paper, did all the things law students are supposed to do, to write footnotes and blah, blah, blah. But, being read, but, I disagree with your conclusion. The court will not overturn a precedent of 68 years, blah, blah, blah. I went on. I finished law school, after I'm in the Army, and I happened to be stationed in Maryland, in Fort Meade, and the Maryland paper, and the Washington paper, said, May 17, 1954, Supreme Court overturned Plessy versus Ferguson, the Brown cases. So I wrote a letter the next day to my former dean. I told you so. Yes. No, you got it. Okay. I feel so big and proud because I told that old cracker. Now, and I was out of school, so you couldn't fuck me.
Yeah.
However, I got a letter back. Dear Eric, it's terrific to hear that you're in the Army and you're doing legal. I was working on legal sections, and that's good. And you didn't get overseas, and you weren't fighting in Korea. I mean, you were facing bullets. Paragraph. I have to congratulate you because you had more faith in the system than I did. I was not secure enough with the idea that the court would overturn such an important precedent. So congratulations to you for having faith about, I felt about this big, because I almost called him a cracker. Communist and everything else. But he's right. It took a leap of faith. The men and women of the NACP, Thurgood Marshall as the leader of the then called the Inc. Fund, of the NACP Legal Defense Fund. The parents of these 5 sets of children who were willing to go through this fight in these 5 different states, South Carolina and Kansas, Topeka, Kansas, and Delaware and the other states. And to stay the course, because you got to start at the trial level and present the case to a jury, and then you got to, not criminal, but to a civil jury, and then you got to go to the appellate thing and argue if you lost below, and then eventually you hope the Supreme Court will take the cases. And it was the perfect execution of the law. The court unanimously overturned this long-standing precedent that said separate but equal. Okay. End on this sad note, or troubling note. Even though we won great victories in the courts, and sometimes in the legislature, the houses of Congress or in the state legislature, we have to remember that there are still people who want to deny to us, based on color, not just brown, yellow, and Mexican, Indians, they want to deny that what they have to us. So the fight goes on, the struggle goes on. We need to continue to turn out good, hardworking people. Some of them are going to be lawyers, they're going to be other things, going to be people who are willing to say, when it's necessary, I'm going to work to protect the rights that we have, the so-called civil rights, which are the legal defined rights that we have by legislature. I want to make work that we, not only that we go to court, but that we fight the legislatures that try to take away our right to vote, which is what they're doing now in many states, including our own great Commonwealth. I want to fight so we get proper wages for the work that we do, which we have to fight for, because there's always going to be a game called, let's make the white folks who have more money, and the color folks or the Mexican folks who have more money. And so the struggle goes on. All of you should think about what you're going to do, what you can do, what you hope to do to keep up the fight. I'm not ready to say game's over, because it's still struggling. And in fact, it's so obvious now, because we have a president of African background, that they can't even act straight. Well, he's not a real American, you know. He's born somewhere else in Kenya or somewhere. He's a Mama guy. That's one of the states. So they made it a state. It's 50 a state. So there's going to be folks who still play that game. Well, you know, they're different. There's black on black crime. Hey, there's white on white crime, folks.
Right.
White guy goes into a skating rink with 4 machine guns and blows people up, or in a mall and shoots a congresswoman and everybody else. That's white on white.
That's white on white.
white on. So we have to remember that they're going to stereotype us.
Thank you, sir.
But we can maintain, first of all, our cool, and get this thing with information, fill that little ring with information, because we're all capable of doing that if you do the work, and be prepared for the next set of struggles, which may be, in some cases, less, because there has been a movement towards equality. But remember, there's still a way to go. The law is one of the ways in which we can achieve the goal that we all want, which is called equal protection, equal pay, fairness. Whether you're a woman, man, Catholic, Jewish, Methodist, there's fairness that our system promises us. Even though the system has never fully agreed with that, it's still there. They wrote those words. Thomas Jefferson wrote them. We hold these truths to be self-evident, that all men.
All men.
Now, he meant men, by the way.
Yeah.
They didn't mean women.
Not women.
Women were subordinate to men at that time, and he literally meant M-E-N, not W-O-M-E-N. But we changed that finally. To 1919, they finally got the vote. People said women can't vote because they don't know enough. Well, women can't be lawyers. My goodness, what's be home, take care of the kids, forever.
Right.
But we're moving in the direction for women. We got to keep that fight up, because there are folks who want to take it away from you. And so that's one of the reasons why I love the law, because you have the tools to change things.
Yeah.
And there are very few occupations where you can change things that dramatically. Yes, there's medicine, you can invent something. Yes, there's engineering. But the law is people we're working with. So I come to you as an unabashed, not ashamed, pro or person, although I know the law is lousy and it's bad, and Zimmerman got away with murder and all that because the law is people, and people are sometimes good, sometimes bad, sometimes indifferent. But our job is to keep them on the straight track. Any questions? Ladies and gentlemen of the jury, you must have a question. Come on. Yes.
I really think we should give him a real big hand.
Yes.
The question of where does the Three-Fifths Compromise come from? It came from the Constitutional Convention. When the members of the Constitutional Convention decided that we have two branches of the legislature, one of which would have each state with two representatives, and the other of which, the lower house, would represent the population. The southern delegates to the convention said, well, count all the people. The northern delegates said, no, you won't. You can't count all them y'all, because they ain't people. I mean, they're people, but they're slaves. And that's unfair. They're not right. And the North said, we won't sign whatever this government you're putting together if you allow all of them to vote, because we'll be outvoted. It's okay in the Senate, it's only two representatives, but in the House, we'll never win.
Yeah.
So we say, don't count them. The Southerners argue, well, they're there. I mean, they breathing air and eating the food and stuff, so we got to count something. So they worked out a compromise. Same way when you bargain for something, you get, it'll be $40, I'll give you 30, okay, 32 and a half. And it was a compromise. It's called the Three-Fifths Compromise, to work that out and to get over to the next question. And there are lots of compromises in the Constitution. The southern states didn't want any action taken on importation of slaves.
So can I follow that question?
Yes, all right.
So was it ever really rectified in the Constitution? I know you.
Yeah, 14. 13, 14, 15. Yeah.
But did they point out African slaves or African Americans? Then was that really rectified? Was that really stated? Was it?
Well,
When they made us Three-Fifths, because I got a white guy. I said, man, come here to the mirror. Let's look at you.
yes.
I said, I got a head like you. I was messing with it. I'm Three-Fifths of the human being. I got everything you got. But I just wonder, was it really rectified?
Well, no, we're trying to keep them from voting. I mean, they're trying to keep us from voting, but the Three-Fifths provision was overturned by the 14th Amendment, because it's not equal protection. 13th Amendment got rid of slavery. There shall be no more slavery. It's the only time slavery was used in the Constitution, by the way. They didn't say the word for slavery was the importation of certain people. They used legal terms. Slavery in the 13th Amendment said there shall be no more slavery. And that struggle is still going on. Now they're trying to keep us out of voting at the state level by asking for voter ID and all that stuff. So they want to. It's great. You got a question?
Just echoing, picking off what he said. Also in the 14th Amendment, in terms of establishing personhood, right, is where we